So one of the myths of criminal defense is something that we've all heard before, right? Which is people are innocent until proven guilty. Well, what does that mean? So what's curious about innocent until proven guilty is that it does two things. Essentially, it says the state or the government bears the burden of proving the person is guilty of the crime for which they've been charged, right? So they start out innocent, and then the state has to build a case against them to show that they're guilty, right? And we tell juries this, we talk about the law, we talk about the burden of proof, we talk about what beyond a reasonable doubt means. That's for another video, but for this one is this idea of innocent until proven guilty. And does that really stand anymore? I mean, what do you think? Does that really mean anything anymore? I would suggest that it may not, right? I would suggest that because the defendant is sitting at that table in the courtroom, because they've made it all the way through the pretrial process and they're at trial, most people who take in the jury will admit, well, they've had to have done something. Whether or not they're guilty of it, whether or not it's what the state's trying to prove, whether or not it's the exact, their behavior matches the crime, all those things are great questions, but they must have done something because they're sitting there. And does that violate sort of our right to be innocent until proven guilty? In some ways it does, right? Except that we are innocent of the crime that the state's charged us with. So that's the one aspect of it, right? And that's the sort of normal aspect that everybody knows. That's the sort of idea out there about innocent until proven guilty. But there's another aspect of it. There's something very different, very subtle about innocent until proven guilty. And the truth is that it's a kind of a misrepresentation. Young attorneys, this one included, when you first get out of law school and you're studying the law, and the law is about words, it's about arguments, it's about facts and law and how they interplay. It's about all this intellectual business, all this intellectual nonsense. And the truth is that when you start to practice law, you realize that the law is about human beings, right? Application of the law to human beings is what really matters. And when you go into the courtroom, this idea of innocent till proven guilty just does not bear fruit anymore. That is a tree without fruit. It is terrible. And as a young criminal defense attorney, I remember trying my first few cases and going in and thinking, well, the state's going to tell their case. They're going to tell their story. They're going to make a story. And that story is going to be that my client committed the crime they've charged him with, right? And then what I'm going to do is I'm going to poke holes in that story, right? And sometimes you'll see an opening statement, there'll be like a puzzle, and the defense attorney will show a puzzle, and they'll be like, look at this puzzle with one piece missing. Well, obviously you can still tell what it is, but look at this puzzle with 25 pieces missing. Well, you can't even tell what it is anymore. You can't even identify the people. You don't know what's going on in the puzzle, right? And they're like, if I can poke holes in the state's puzzle or poke holes in the state's story and you can't tell what's going on and you have some reasonable doubt, well, maybe that, think about the puzzle thing, right? I actually used this in some of my first jury trials. And then I realized that that process was ineffective, right? And it was ineffective because I'm required to tell a story of innocence. The defense, is better served by telling a story of innocence. The prosecution is going to tell a story of guilt. The defense should tell a story of innocence. We should put together a story of the case, matching all of the facts, matching all of the information that includes your client being innocent of the crime, not guilty of the crime for which they are charged, right? And it's interesting because there's a provision in the law in the case of circumstantial cases, right? When there's no direct evidence of someone committing a crime, no video, no eyewitness, no one actually saw the crime. This happens quite a bit. And the case is simply circumstantial, right? There's evidence that, if believed, will lead you to another fact, and from that fact you can infer guilt, right? You can decide someone's guilty from those secondary facts. But the facts you're being given are just facts about evidence that lead to other facts, which then lead to guilt. That's called a circumstantial case. And if a case is purely circumstantial, based solely on circumstantial evidence, the government has to prove the case beyond all reasonable doubt, or the positive aspect of that statement is to the exclusion of all reasonable hypotheses of innocence. Let's say that again. This is very important. The government has to prove the case to the exclusion of all reasonable hypotheses of innocence. What does that mean? They have to exclude every reasonable, believable story about your client being innocent. That means if the defense can offer a theory, a story, explain the case, the facts and evidence of the case, and that facts and evidence includes your client being innocent, not guilty of the charge, and the state fails to rule that out, the state fails to show that that's an unreasonable story or an unbelievable story, then your client's not guilty. And that is the key to next level criminal defense, right? Anybody with any experience under their belts, anybody with 10, 20, 30 jury trials, I have more than 60 jury trials. This is how you defend people. You defend people by creating a story of innocence. And it starts when the client walks in the door and you start talking about the case and you start putting together in your head, tell me the facts, tell me what's going on, tell me what happened, tell me what the circumstances are, and you start putting it together in your head, how is this person innocent of this crime? How did these facts come about with another person, with another set of circumstances, from something that doesn't include guilt of your client? That is the key to criminal defense. Innocent until proven guilty, but it's actually innocent and being proven innocent by your criminal defense attorney. That's what we do at the Ambo Law Firm. That's the way we try cases. That's the way we take on the government. That's the way we fight. If you need help, if you've been charged with a crime, if you're under investigation, you need a strong, powerful criminal defense team, come hire us, come talk to us at the Ambo Law Firm. We're here to help.